If you're injured on the job, can you still sue? This is Gary Berger of Berger Law. The answer is yes. We were in court this morning in this case where our client was injured because of the negligence of co-employees. So usually if you're working and you're injured, your exclusive remedy is under workers' comp, and you should make that work comp claim. We do that too. However, under certain circumstances, you can also have a claim against a third party. For instance, if you're working and then a third party injures you, like so you're driving for work and a truck comes and hits you. We tried a case over in Illinois a couple months ago where the state dumped some ice on our client's windshield and caused them injury. So if a third party injures you, you can still have that claim even if you're injured on the job, even if you're working. You make your work comp claim, you get your benefits, and then you make the third party claim. That comp may have a lien or want to get their money back in Missouri under 287.150 or the Rudiger case. The other way you can do it, though, is that Missouri has a statute, and we argued this morning, that an employee, a co-employee, what if one of your co-employees injures you? That happens all the time. You're always working with people on a team. An employee shall not be released from liability for injury or death if the employee engaged in an affirmative negligent act that purposefully and dangerously caused or increased the risk of injury to you. So if that happens under Missouri Statute 287.120, you have a claim against your co-employees, and that's okay. You're not taking money from them personally. They have insurance to cover that. But we have many actions where supervisors or employees break the rules and act dangerously and injure people on the job. And when that happens, they should be responsible for that harm. And Missouri creates an exception. We had a recent situation here in downtown St. Louis where tragically, terribly, 2 people fell to their death down an elevator shaft in a building that was being rehabbed on Washington. Those employees have a remedy against whoever failed to tether them, the elevator company that failed to secure that, if there was one, or anybody who's not other standards of care, other rules that you have to be tethered to prevent people from falling. So when that occurs, you have a claim against those co-employees, and so workers' compensation is not your exclusive remedy. Now, it is true that you get immediate relief through work comp. You want to go through your work comp claim, and you want to get all those benefits because you need to do that. However, at the same time, you need to be mindful that you may have another claim against a third party, maybe a better claim against a third party. I have had cases where people are driving, get injured, and I say, you know what? Rather than letting the employer control the medical and the work comp claim, this truck hit you, they got a lot of insurance to cover your injuries. Let's pursue a claim against that. So those are the things you weigh and that kind of stuff. Make sure when you're injured on the job, you file a report of injury regardless and do those things. I have books on my website, burgerlaw.com, about work comp, about auto crashes, to try to give you information about all this. We also do these videos to try to educate you about that as well. If you have any further questions other than what I did, we always answer your questions for free at Berger Law at 314-542-2222, 618-272-2222. Email me at gary@burgerlaw.com. Message us on Facebook. Thank you very much.